Assalamualaikum warahmatullahi wabarakatuh. My name is Anis Shazlin binti Roslan and my metric number is 1212324. Okay, let's proceed to the establishment of the Native Court of Sarawak. Okay, firstly, the Native Court was first established by Raja Charles Brooke in 1970 as the Native Mohammedan Probate and Divorce Court. Suicide twice a week or when necessary for the settlement of marriage and judgment, rights and divorce cases, and division of property occasioned by divorce or death. Then, the court was presided over by the principal datu or chief. Next, during the British colony, particularly from 1947 to 1955, the native courts underwent major reforms, i.e. the passing of the Native Court Ordinance 1955 was significant development in the evolution of the native courts. The court's jurisdiction will extend to all native of Sarawak on matters of customary law or customs. Furthermore, apart from the native chiefs, the residents, district officers, native officers, and later on the Sarawak administrative officers were given magisterial powers to preside over native courts cases. Hence, the native court's work became one of the main functions and duties of the residents and district office. When Sarawak gained her independence through the formation of Malaysia in 1963, the right of the state, i.e. Sarawak, in the Federation of Malaysia to constitute their own native courts was firmly enshrined in item 13 of list 2 paragraph A of the 9th schedule of the Federal Constitution. Then, after some time, the Native Courts Ordinance 1955 was found to be riddled with many deficiencies, i.e. the appellate system was unsatisfactory. Apart from that, the poor records keeping by the lower courts which could give rise to protracted litigations. Furthermore, there was huge backlog of cases before the residents' native court and district native courts. The residents and district officers need more time and attention for other matters. For example, the implementation and monitoring of the development projects. At times, their judicial responsibilities could cause friction to the good public relation between them and the local public. Thus, there was an urgent need to repeal the 1955 ordinance. With the coming into force of the Native Courts Ordinance 1992 on 1 June 1993, the 1955 ordinance was repealed. Okay, lastly, the Native Courts Ordinance 1992 brought about the establishment of the Central Registry Office at Kuching. The Chief Registrar maintains the Central Registry and supervises and monitors the administration of the Native Courts throughout Sarawak. All the District Office and Sub-District Office become the Registry Office of the Native Court. Okay, that's all from me. Thank you.
Hi, Assalamualaikum everyone. My name is Asha Ashura binti Azman and my matrix number is 1212321. So now I'm going to continue about, let's look at the slide. Okay, hierarchy of native courts in Sarawak. Okay, as we all know, native courts in Sarawak, there are two divisions of hierarchy. Okay, which is number one is appellate court. Number two is primarily courts of original jurisdiction. And each of these courts, which is the appellate court is considered as the high court, and primary courts of original jurisdiction considered as lower court. And each of all of these courts has their own function. Different function lah. Okay. So for now, I'm going to brief you all about two courts only. Native Court of Appeal. And number 2 is Residence Native Courts. Okay, let's go through to the next slide. Okay. Okay, now let's look at the slide. Okay, focus on the slide. Okay, I'm going to brief you all about Native Court of Appeal. Okay, in the Constitution, which is the Native Court of Appeal consists of a president, which has been appointed by the Yang di-Pertua Negeri. Okay, which Yang di-Pertua Negeri? Yang di-Pertua Negeri Sarawak. Okay, a president must be appointed by the Yang di-Pertua Negeri. Consists in Native Court of Appeal. Okay, number 2, the president of the Majlis Islam or the Ketua Majlis of the Majlis Adat Istiadat Sarawak. Okay, number 2, in Native Court of Appeal, there is president of the Majlis Islam or the Ketua Majlis of the Majlis Adat Istiadat in Sarawak. Okay, the third one is any person appointed by a Temenggung and nominated by the president in consultation with the chief registrar. Okay, what is their function? What is that person which has been appointed by Temenggung? Okay, what is his function in Native Court of Appeal? Okay, 2, to hear any particular appeal. Okay, since this is Native Court of Appeal, of course, there is power to hear appeal. Okay. Okay, so now let's move on to jurisdiction and powers at Native Court of Appeal in Sarawak. Okay. Number 1, there is appellate jurisdiction. Or in bahasa we call it as bidang kuasa rayuan. In bahasa, but in English we call it as appellate jurisdiction, which is Native Court of Appeal in Sarawak has power in appellate jurisdiction. Okay, bidang kuasa rayuan. Okay, which type of appellate jurisdiction that they approve, which is only things that related to native law or custom. Okay, understood? Okay, so do you guys understand which appellate jurisdiction, meaning that only appeals that concerning on land and native status can be appealed in Native Court of Appeal in Sarawak. Okay, next, on the termination of the appeal, Native Court of Sarawak, okay, and other courts exercising appellate jurisdiction, okay, other court that exercising appellate jurisdiction bidang kuasa rayuan, okay, may dismiss the appeal. Okay, when at the termination, the courts that practice appellate jurisdiction may dismiss the appeal. Number 1. Number 2, rehear the case itself or order the case to be heard by any lower court. Meaning that Native Court of Appeal can rehear the case at Native Court of Appeal or can order the case to be heard by lower court. The other lower court lah. Okay. Next, they may hear further evidence or order the trial court or any other native court having jurisdiction to hear further evidence. Meaning that they may hear further evidence or they may order the trial court or any other native court having jurisdiction on this to hear further evidence. They also may order a retrial. They also may set aside, reverse, amend, or vary the decision of the lower court. Vary the decision means change the decision of the lower court. Vary in English means, in Malay means mengubah. Okay, or they also may make such other order. Okay. Next, the second jurisdiction of Native Court of Appeal in Sarawak is revisionary jurisdiction, or in Malay we call it as bidang kuasa semakan. Okay, under SNCO or Native Court Ordinance 1992, Native Court of Appeal has the power to revise when there is an error. Okay, meaning that Native Court of Appeal in Sarawak has power to revise when there is an error material to the outcome of the cases, or a miscarriage of the justice lah. Okay, which is the outcome of the cases, which is the judgment has some error and injustice in it. They might or they may revise, okay, when there is an error. Okay, now let's move on to Residence Native Court. Okay, in Constitution, Residence Native Court consists of Residence Native Court presided over by a person who is holding or acting in the office of residence of a division. Okay, which is Residence Native Court presided by a person who is holding or acting in the office of resident of a division. Okay. Number 2, under the subordinate courts, Act 1948, Act 92, the residents and district officers are ex officio first class magistrate. And the last one is to relieve residents from burden of hearing native court cases. Okay, because when we have burden, so what is the action? Yang di-Pertua Negeri may appoint ex-resident or such person as he may deem fit and proper to preside or to mempengerusikan over the residents native court. And the presiding officer is assisted by not less than 2 and not more than 4 assessors. Okay, that's the requirement. Okay, so now let's move on to the jurisdiction and powers. Okay, there are three division. Okay, A, original jurisdiction. Okay, under section 20 of Native Court Ordinance, which is Residence Native Court has power to hear and determine, number 1, whether a non-native has become identified with a particular native community according to section 9 Land Code. Okay. Number 2 is whether non-native who is subject to a particular system of personal law has become subject to a different personal law. Okay, related to particular system of personal law and different personal law. Okay. Number 3, whether a person subject to a personal law of a particular native community has ceased to be so subject. Ceased means berhenti. Okay. Let's move on to the appellate jurisdiction. Okay, number 1, the residence native court only hear case concerning land matters only. Concerning land matters only. Okay, because this is the name of this court is Residence Native Court. Of course, it is related to the residents only. Okay. Okay. The example is in case Linawati Abdullah versus Abang Sukori, Abang Haji Kopil and another. This case they appeal. Okay, they appeal their case at the Residence Native Court. Okay, because of what? Because their case is related to land matters. Like that. Okay guys, let's move on to the last part of my presentation, which is the revisionary jurisdiction of Residence Native Court of Sarawak. Okay, in this revisionary jurisdiction, they have power to investigate any case heard by an inferior court. Which means any case that has been heard by the lower court, they have power to investigate it. Okay. Number 2, exercise any of the powers which it might have exercised had there been an appeal. Okay, meaning that they can exercise any powers that might they exercised if there is an appeal. Okay. Number 3, be exercised after 12 months from the conclusion of the case heard by the inferior court, which means all of these powers must be exercised after 12 months from the conclusion of the case heard by the inferior court. Okay, remember, 12 months from the conclusion which has been heard by the inferior court, then they might exercise their power lah. Okay, understand? So thank you, that's all from me. I hope you guys understand what I'm trying to brief to you all, and may Allah subhanahu wa ta'ala bless us all. Thank you so much. Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Nabila binti Muhammad Rizal and my metric number is 1212335. Today I will talk about the constitutions and jurisdiction of District Native Court, Chief Superior Court, Chief's Court and Headman's Court. Before we start, do you know that the courts that I mentioned just now are collectively referred to below as Native Court? They are classified in the Sarawak Native Courts Ordinance 1992 as courts of original jurisdiction, although all the courts except the Headman's Court have appellate jurisdiction too. These courts handle the cases concerning breach of native customary law. Section 5 of the Native Court Ordinance 1992 provides that the Native Court in Sarawak shall have all the original jurisdiction in the following matters. First, breach of native law or custom where all the parties are subject to the same native system of personal law. Then cases arising from breach of native law or custom relating to religious, matrimonial or sexual matters where one party is a native. Next, civil matters excluding cases under jurisdiction of Sharia Court which the value of the matter does not exceed 2,000 ringgit. Next, any criminal cases of a minor nature which are specifically enumerated in the other IBAN or other customary law and which can be adequately punished by a fine not exceeding native court may impose, and also any matter concerning which jurisdiction have been conferred upon the native court by any written law. The native court in Sarawak do not have jurisdiction on this matter. First, offences alleged to cause death and offences under the Penal Code. Then marriage or divorce under the Law Reform Marriage and Divorce Act 1976 and the Registration of Marriage Ordinance 1952, unless the claim relates to bride price or adultery and based only on native customary law. Next, land with title or interest in land registered under the Land Code and also breach of the Islamic Family Law Ordinance and rules or regulations made thereunder or the Malay custom of Sarawak. Then all matters falling within the jurisdiction of the Sharia courts under the Sharia Court Ordinance 1991. The District Native Court is presided by ex-officio first-class magistrate appointed under the Subordinate Court Act 1948. The magistrate is assisted by 2 assessors who are either appointed by him or by the resident. The District Native Court can hear cases on appeal from the lower court involving land where there is no title issued by the Land Office. However, no appeal lies to the District Native Court in matters concerning breach of native customs and matrimonial sexual and where judgment of the Chief Superior Court is declared to be final and conclusive. The District Native Court has the same supervisory powers as other appellate courts. It may either on an application by an interested party or on its own motion, investigate any case heard by an inferior court and exercise power which might have been exercised had there been an appeal. The Chief Superior Court consists of a Temenggung or Pemancar sitting with two assessors, or both Temenggung and Pemancar sitting with one assessor. In a case of community following an IBAN system of personal law, Section 4, Clause 6 of the Native Court Ordinance provides that the Chief Superior Court may be constituted of a Temenggung or Pemancar, or both sitting in either case with two assessors. The Chief Superior Court is the highest appellate court for the following matters. First, breach of adat and offences relating to matrimonial, religious, and sexual offences. For civil matters where the value does not exceed 2,000 ringgit, and minor criminal offences. The decision of the Chief Superior Court in respect of all matters under Section 5 of the Native Court Ordinance, except for land dispute, is final and conclusive. The Chief Superior Court has supervisory jurisdiction over inferior courts. The Chief Court and the Headman's Court can, on their own motion or under the direction of the resident, refer their cases for hearing by the Chief Superior Court under Section 5, Clause 6 of the Native Court Ordinance. The Chief Court consists of a penghulu with two assessors. In cases involving a community following an IBAN system of personal law, the penghulu sits in the Chief's Court with two tuan rumah to assist him. The Chief's Court also hears appeals from the Headman's Court. One can present an appeal as of right where the matter involves a question of native law and custom. However, when it involves a question of fact or meets question of law and fact or against a sentence of imprisonment, an appeal can only be lodged with leave of the resident. The Headman's Court consists of a headman and two assessors. However, in the IBAN community, a Headman's Court may be constituted of a tuan rumah sitting without assessors. A Headman's Court may hear all matters stated under Section 5 of the Native Court Ordinance, except for land disputes where there is no title to the land. That's all from me. Thank you. Next, we will move to the next topic, which is the power of the Native Courts of Sarawak.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Okay, right now we are going to talk about power of the Native Court of Sarawak. Okay, in this topic, there are 4 parts. First, power to impose penalties. Second, recovery of penalties or compensation. Third, imprisonment in default of penalty. And the last one is power to award compensation and to make orders. So to find out all these 4 parts, we are going to look at the Native Courts Ordinance 1992. Okay, we can find power to impose penalties in Section 11 of Native Court Ordinance 1992. So here we have already highlighted the duration of imprisonment in green and the amount of fine in yellow. These courts in Section 11 are listed in descending order, meaning that the first court is the higher in the hierarchy, followed by the second, third and fourth. So, let us take a look. A. District Native Court imprisonment not exceeding 2 years and a fine not exceeding 5,000 ringgit. Chief Superior Court imprisonment not exceeding 1 year and a fine not exceeding 3,000 ringgit. Chief's Court imprisonment not exceeding 6 months and a fine not exceeding 2,000 ringgit. And Headman's Court fine not exceeding 300 ringgit. But let us look at the blue phrases. Excess of the fines prescribed herein, compensation authorized under the Adat IBAN or any other customary law, meaning that if the amount of penalty exceed the prescribed penalty in Section 11, the Native Court still have power to impose the penalty if it is authorized by Adat IBAN or other customary law. Okay, in Section 17, we can find the power of Native Court in recovery of penalty or compensation. So, let us look at the highlighted phase. Levied by the sale of any property belonging to the person who is penalized or ordered to pay compensation, meaning Native Court has power to force those who fail to pay the penalty or compensation to sell their own property. Okay, in section 18 of Native Court Ordinance 1992, we can find the power of Native Court to confer imprisonment in default of penalty. Meaning, if any person fail to pay the penalty, so Native Court have power to confer imprisonment. So here in section 18, there is a list of the amount of penalty and the imprisonment period. So if the penalty does not exceed 50 ringgit, the imprisonment period will be 1 month. Not exceeding 100 ringgit, 2 months. Not exceeding 200 ringgit, 4 months. Not exceeding 500 ringgit, 6 months. And exceed 500 ringgit will be 12 months. So here, let us look at the green one. Nothing in this section shall confer on any native court over which a magistrate does not preside power to direct that any person be imprisoned. Meaning that if the native court want to confer imprisonment, want to give sentence of imprisonment, the native court must be presided by magistrate. If it is not, they can't grant the imprisonment. Okay, in section 19, we can find the power of native court to award compensation and to make orders. So, here in section 19, we can find 5 types of orders. First, award compensation. For example, costs and expenses suffered by the injured person. Second, penalty. For example, in the form of cash. Third, restitution of any property. It means to restore or repair property, for example, houses, buildings, and so on. Fourth, specific performance. For example, restrict the criminals from going abroad, block their bank account, and so on. And the last, forfeiture. Forfeiture meaning to seize their financial assets, the criminals' financial assets.